back. Just over a week ago, INEC released the timetable for the elections, and according to that schedule, the presidential elections will hold on the National Assembly elections will hold on the 14th of February, Valentine's Day next year, and the presidential will hold exactly 2 weeks later, which means that according to that schedule as well, registration of voters will begin any time from now. To look at this focus with us, preparations for 2015, it's my pleasure to welcome Mr. Nelson Obuaya, who is a lecturer at the law school. Good morning.
Good morning.
We also expect two other people to join us, an INEC commissioner as well as another legal practitioner. Well, you're not a practitioner, even though
I'm a
you're
legal practitioner.
Okay, you're a teacher as well as
a legal practitioner.
Yeah. Okay.
I'm the vice chairman of Lagos branch of the MBA.
Oh, lovely, lovely, lovely. So what are your thoughts about this timetable, and how feasible do you think it is?
I think timetable is feasible to the extent that if it's religiously followed, it is okay, because this is 2014 and already the election is due for 2015. If by now we don't have the calendar, then we'll be running into murky waters. Mm-hmm. So it is important that we understand where the INEC is coming from. The fact that the election must hold in 2015, and they have the statutory duty to bring out the calendar, and if they don't bring this calendar early enough for people to know, what are the schedule, and begin to prepare themselves along the line, then the election is going to have hitches. Mm. So the first step is to bring out the calendar, and people begin to analyze it and see where it is right or wrong, and within a short time they can tinker with anything according to people's opinion. Mm. So that is why I feel that it's timely, if not even late, to even bring out the program by now.
Mm. I was just mentioning to Alero some of the conversation at Chatham House in London recently, where people were saying that the calendar, the timeline is too tight, and that a lot of people would expect that it will be easier for people to start campaigning a lot earlier. What's your thought about that?
I'm saying that INEC ought to have even brought this timetable earlier than now, because the election is already fixed for 2015. Mm-hmm. So everything is now in between months from now to that designated period. And remember that post-election quarrels is part of the problem.
Yes.
So you have to give a clear way for
all that to happen.
Yes. So that's why they are seen in that tight situation. So ordinarily, if they had brought it late last year, people would say, oh, why bother us with election issues when election is almost 1 year ahead? But now they came early in January, and then people are saying it's tight.
Yes.
So that is the problem. Let's look at the example of the law school. If you come into the law school, as you are picking your form, you already know your exit point. You already know everything. And you follow that program religiously to the end. If Nigerian will emulate that calendar system from the law school, there's no need to complain, because it's about seeing this thing and say, okay, let us do what the calendar says. If we have any issue with some points in the calendar, it's timely to point them out. So to me, the import of this election calendar is divided into at least 3 segments. Look at the segment of preparatory, things that will happen before the election. Issues of nomination, issues of
registration
campaign,
of
registration of voters. So these are major segments of pre-election issues. And then remember that in dispute resolution aspect of it, there are 2 arms. The first arm is the pre-election matters and post-election matters. The pre-election matters have no time limit to agitate. So if the INEC is not careful in managing the pre-election matters, they will affect the post-election issues. At the time you finish the election, disputes arising from the pre-election issues will bug the system, because those ones don't have time limit, and they have to go through all the way to the normal courts, not election tribunal courts, to the Supreme Court. You know?
Okay. Post-election disputes, for instance, there have been debates and debates and debates regarding the time span within those disputes should be settled. And some people are still insisting that those things should be sorted out before the swearing in of whoever. And whoever is not bogged down after they've been sworn in, and cases of them being, ousted after they have been sworn in because somebody else has won the case at the tribunal. So to prevent all those kinds of things, what do you think about that suggestion?
You see, that has been a very major debate all over. And there are two schools of thought. One school of thought is saying that why disturb people's rights to fair hearing? That speedy justice also don't guarantee quality justice. That if you put the system so close, everybody is looking at time, not the substance of the dispute. So they will make sure that they will use technicalities to frustrate true justice, and then time would have passed and justice would not be done to the aggrieved party.
How much time is good enough time for people to say long enough for campaign, long enough for tribunals, and long enough for us to prepare for the swearing-in ceremony?
That's why I'm saying that it is not because it's like an ad hoc arrangement now. These three issues supposed to be structured properly and given sufficient time. Because
he's saying what is sufficient time?
What is sufficient time in the circumstance? The 90-day rule ordinarily is sufficient, but given the Nigerian legal system, that issues of appeal, issues of constitutionality, of those technicalities are so much, and these are constitutional rights that now bring about the problem. Look at the problem that you should have terminated the election matters at the Court of Appeal, like the issue of governorship and all. We saw the problem that it brought into the polity. It overheated the system. They felt that the Court of Appeal was too powerful, and that the Supreme Court, which is the apex court, is no longer having power to regulate that aspect of dispute, whereas the Constitution guarantees that the last stage of